Good morning, everyone, and thank you for joining us. I am Sherry Feuerbacher, the Chair of Professional Development here at Metrotex, and we are so thrilled today to bring to you some very esteemed guests from TREC. We are welcoming 3 people from TREC today that are going to give us an update on things that are happening there, as well as they've promised to take some of our questions here at the end of the presentation. So without further ado, I'd like to introduce to you Chelsea Buchholtz, the Executive Director, Vanessa Burgess, our General Counsel, and Michael Molloy, Director of Enforcement. And we're going to start this meeting off with Chelsea. And at this point, I'll hand that over to her and she can take over.
Great. Thanks, Sherry. And good morning. We're delighted to be with you. I wish it was in person. Hopefully someday soon that can happen. I am grateful for the ease of opportunity to be with you and other local boards around the state just because of Zoom. I hope we continue some of it, but there's something really special about being in person. So I look forward to that opportunity as well. As Sherry mentioned, I'm Chelsea Buchholtz, Executive Director. I have been Executive Director for a little less than 2 years. I still feel very new, and I often wonder how long I can call myself new, but I'm going to keep going with that for as long as possible. I was General Counsel before I was Executive Director, but just for a short time from about March through December of whatever 2 years ago was. I've lost, with COVID, I feel like dates mean nothing. But when I became Executive Director, I hired Vanessa Burgess, our General Counsel, who's with us today as well. Neither one of us have a background of real estate. We are both learning as we go. Both have backgrounds in government, in kind of the government sector, state agency world. Also with us today is Michael Molloy, our Director of Enforcement, who has been with the agency many years and has a vast knowledge of our rules and law related to licensing real estate agents. So we're delighted to be with you. We're each going to go through a few slides with you, really based on just topics that you ask for and that we are often asked about. But feel free to ask questions along the way. We'll have some time for questions at the end, and we'll try to be really respectful of your time. I like to start just by highlighting our mission. There's a lot of words in this mission, but I'm going to highlight the top and the bottom part of this mission. The first is to safeguard the public interest and protect consumers of real estate services. This is really a cornerstone of the work that we do, is to protect consumers. And then at the very end, you can see that through the work that we do, we are also facilitating economic growth and opportunity across Texas. And so where that comes in is where we support the work that you do. So that's our always our tension between consumer protection and supporting the work of the license holders. Both are equally important, and we like to keep the right balance there. I'll provide you with a few updates, and then I'll pass it to Vanessa here in a minute. But first, just in terms of operations here at TREC, we remain mostly remote. That has ebbed and flowed, likely for you as well, through various stages of the pandemic. Austin was recently at stage 5, down to stage 4, and now we're heading in the right direction at stage 3. So we remain remote, but we're looking to bring employees back just as soon as possible. Once we do that, we'll be able to be open to the public, but that should have very little effect for our license holders. We are able to do everything we need to do remotely. We still have staff on site to process checks that come in the mail, to process all of our mail, but otherwise we can do everything we need to do remotely. We have a commission meeting, which we kind of operate within the cycle of commission meetings. They happen 4 times a year, We do a lot of prep work for those, getting ready for those meetings. Our next one is November 8th, and I encourage you to watch that meeting. They are streamed through our website, which is trec.texas.gov. I think that is a really helpful way to understand what's happening in the commission's work and to see what's coming down the pipeline for our license holders. So I encourage you to do that. One thing that will be discussed at the workshop following the commission meeting for our commissioners is what potential initiatives the commission wants to focus on in 2022. And they have a lot of different ideas. The things that seem to be coming to the top for them right now are wholesaling, which is a conversation across the country, but just does there need to be further regulation on the practice of wholesaling in Texas? And then also license portability. What does it look like for out-of-state license holders to come to Texas? We have some of the strictest requirements in the country. And so how can we make it easier for out-of-state license holders to come to Texas without diminishing the quality of our license holders? And so I think that'll be a conversation. It already is, really. And then how to better outreach to people like you. That's very important to our commission and to each of us, that we outreach to our license holders and also to consumers so that they have a better understanding of what we do. Just a little snapshot into what we look like today. Our total license count is at a record high. We have over 218,000 license holders. That was as of the end of our fiscal year, which is the end of August. Almost 219,000. That's over the last 10 years, we have grown faster than the population of Texas, just to give you an idea. So in fiscal year 2001, we had 114,000 license holders. So we have grown substantially over the last 20 years. I understand that y'all have an interest in what is being required for the HOA website. There was a bill that was passed this last legislative session that requires us to establish a database to accept management certificates for all HOAs. So right now, those certificates are submitted only to the county clerk where an HOA exists. And TREC will not license or register HOAs in any way. There will be no enforcement on HOAs. We are not a regulatory agency that oversees them. We are simply being asked to establish this website, basically a portal for the submission of these management certificates. That portal will be complete by our deadline of December 1st, hopefully a little bit before that. And the way this will work is that there's a deadline to file. For all existing HOAs, there's a deadline to file the management certificate by June 1st of 2022. And if an HOA, if a new HOA files a certificate with the county clerk after December 1st of this year, then they'll have only 7 days to file that certificate with TREC. So the purpose of this database, according to the statute, is to make this data accessible to the general public through the internet. So basically, this will be a mechanism, an avenue for homeowners to find their HOA, to get contact details for that HOA, and for us to have a better idea of how many HOAs are out there. It's because there's no central location for that information to be housed, there's a lot that we don't know. So it'll be interesting to see what that looks like. I'm going to pass the mic to Vanessa to talk a little bit about the updated contract forms.
Good morning, everybody.
Oh, you're muted.
Okay, good morning. Okay. I was saying is I have a little bit of an allergy voice this morning because I live in Austin and constantly have an allergy voice. I'm going to go through a few different topics some of which were requested, some of which I just try and present on when I can. I'm really going to highlight just a few things on the new contract forms because I don't know how new they are anymore. But they are so relevant to what you do every single day that I think it's important to cover them whenever I can. I will say, I think this is probably one of the most important things I can show you, right? If you go on our website and you go under the contract section, you want to open the 1 to 4. If you want to see what happened to those contracts, you can, where that little arrow is, it says see a red line. It will show you all of the changes that have been made to that form. And that's true for any of these forms that have undergone changes recently. We've started including red line versions. And I just think that's so helpful because you can see exactly what happened. So, please use this as a resource. Right now, if you were to look at the 1 to 4, this is actually an old slide, but if you were to look at the 1 to 4, there are 2 red line versions because we have made some new changes related to PID disclosures that are required now by new legislation. So you'll see a red line 2015, and I'm going to guess it says red. Helpful if you've got anyone who's kind of struggling with the changes or learning the changes. I think it's just a really good tool, and we will keep putting those out for you whenever we make the changes. Okay, so I think I go to the next slide. Chelsea, so you're running this, right, Chelsea? The slideshow. I don't think I have the ability to change it. Okay. Here, I summed this up really quick. Okay, paragraph 5. It's a process change. I will say this. Can you all hear me? It's saying my internet is not great. So tell me if you can't. Chelsea, just start frantically waving or come get me. Thank you. Okay, so paragraph 5, Chelsea mentioned, I have much more of a state government background. And when I got here, it was really when the paragraph 5 changes were starting to be in discussion. When I say paragraph 5, the combo of option and earnest. And since I've been here and since all this has started, this is where I say this is where all the feelings are on the contract changes. Like, people had a lot of feelings on this. We received first round of publication when we posted this to rule, 200 pages of comments. I will say 160 of those pages were related to this change. And then when we did it the second time, I thought, okay, everybody said what they have to say. Surely we're not going to get another 200 pages of comments. 200 pages of comments later, 160 of them being related to this change. There's just a lot of feelings on this, and I think that's because it's truly a process change. I am going to do, if you will give me 1 second, I'm going to go over to Chelsea's office and use her computer.
We are officing next door. I hope I don't have the same internet issues, but Vanessa is walking into my office now. I'm sorry for the trouble.
Oh gosh, now I have to control the slides. Okay, is this better?
Yes.
Okay. So what I was saying is there's been a lot of feelings on this one. I think at this point, implementation is happening. There were a lot of concerns, how is title, is title ready for this? Well, title actually requested this. This is one of their initiatives. And I know TLTA has been doing a lot to get the message out. I think probably we're through some of the implementation struggles, which are just natural. Broker Lawyer is watching this, but for the most part, it seems to be pretty successful. It's, like I said, if we think of it more as a process change, I have a really distinct memory of like showing up in a parking lot and meeting my agent and like handing him 2 checks and having no idea what was happening. And I dug those checks out of the, back of my drawer, and I still have no idea what happened there. So when I heard about this and being able to combine them, I thought that sounds great. That's 1 check. But that's why I say get out your calculator. That 1 check makes a difference, right? Because if your numbers or if their numbers are off, it's going to go first to option fee, and then it's going to go to the earnest money, and then it's going to go to additional earnest money. So you just want to make sure that you've got the math on that right, know the process. You'll note there's language in there now, the Saturday, Sunday legal holiday now applies to the option fee, and that makes sense because you can combine it and it's going to one place. And the only other thing I'll say is the additional option period fund delivery has not changed. So that's still done via the amendment. And that language talks about, seller has received. So that's going to the seller. And that's just kind of a summary of what's going on there. I would say the comment we get the most on at broker lawyer still is, are they going to add a 5 p.m. deadline to this provision? I think the answer is no. And I'm basing that on the last 2 meetings where they have said no. And that's for a lot of reasons. It didn't exist before. And the thought is, they don't want to get into the litigation components of that, just keeping it till midnight. There's questions on how that will deliver. There's the virtual, there's the ZACM, I think it's called. So they're not going to make that change of adding it to 5. If people keep making that change, maybe someday, or that request, maybe someday that'll change. But the last 2 meetings, they've been pretty firm on that one. Okay, now, how do I change that? Oh gosh, yes. See that thing that says change slides here. Okay. Not change. There we go. All right. Paragraph 4. Okay, so I said that paragraph 5 is where all the feelings are. Paragraph 4 is there were some big changes to paragraph 4. And if you're a listing agent, I would get really familiar with the new addendums that came out. I get really familiar with paragraph 4, what you need to check in there. So it's really all about upfront disclosure. And I think right now people are, maybe it's slowing down a little bit, but people want to get things moving. They want to make a bunch of money. They want to sell their house, make a bunch of money, which I get. But if you've got any of these, if you've got residential leases, if you've got fixture leases, think solar panels, or natural resource leases, this is requiring a lot more work up front as it pertains to disclosure of these leases. So you as the agent are going to want to be really familiar with that. You're going to want to be really familiar with the forms. So you've got the residential lease addendum, fixture lease addendum, and then you've got a provision in 4 that talks about natural resource leases. So I'll just note some of the highlights of what I think are important in this. On the residential and the fixture lease addendums, just make sure that when you're working with your client on either side, right, there are leases that control there. There are separate leases. They have their own terms. You need to make sure that, that solar panel lease can be assumed. You want to make sure that when you're disclosing, there's like a number of items you have to disclose about the state of the residential lease. You need to work with your client and make sure that they're ready to go. They're ready to disclose on that, because there's remedy language in there. There's an option to terminate in there. Those are really important. So you just really want to be familiar with those forms and what they mean. And if it gets complicated, right, if you have a situation, the forms even say it, consult with a private attorney. And I think that I'm going to get into unauthorized practice of law in a little bit. I think that's really important. So the more familiar you are with those forms, I think the better. So read them and read them again. And then on natural resources lease, something that there's language in there that I think is really important. It's natural resource leases to which seller is a party. And the thought is you should know if you are a party to a natural resource lease. So it's not necessarily every natural resource lease that has ever existed for all times. It's the one to which the seller is a party. Okay. And I have not seen if there have been questions, but if there are, please tell me. Okay. So unauthorized practice of law. This is something that I understand everyone has an interest in, and I can speak to it. I can speak to a little bit. I'm going to cover a couple of different things on that. First is escalation clauses. So I'll do a little bit of self-promotion here, guys. I recently wrote an article and appeared in what I now consider to be a viral video on TREC's Facebook, because people have actually watched it, on escalation clauses. And it, and I'm kidding, I'm not actually viral. I think it's had some views, and I'm excited about that. It talks, that article specifically talks about the language as it pertains to drafting escalation clauses. And it's, you know, there's statute and rule don't allow for an agent to draft the escalation clause itself. How many times does that come up in your practice where you're actually being asked to draft something? I don't know. I think it certainly happens. I think what you're seeing a lot more of now is forms that already exist. And, you know, can you use them? What happens? What if my client wants me to, you know, write this language in and is giving it to me specifically to write this language in? And I'm going to cover some of that. I think that's what my next article is actually going to be on, is the sort of the real world situations, because I know, like, I mean, I don't know because I'm not in your industry, but from what I hear from the folks in your industry is it is wild out there with the escalation clauses. And it makes me happy to know that everyone I hear say that also says, and it makes me really nervous. And that is because, right, what those clauses are doing is it's adding a new clause to the contract. It implicates the rights of both parties. And it's creating at times some pretty significant, I just lost the word for it, but I mean, this, like, given the way the market is right now, that clause had better be, the person who is wanting that clause had better be very clear as to what they're saying. Because if you're saying I'm going to go 1,000 over best price, right now, you know, the highest offer can be really significant. You have no idea. So all of that is to say, you advising on the implications of that, you drafting the language as the agent, you putting it in there, you're getting into what can easily be considered the unauthorized practice of law. And you don't want to do that because it's a violation of rule, it's a violation of statute. On our end, right? That's gonna wind you up in enforcement should someone file a complaint. And I'll say equally significantly is, you know, you don't want your client in court over a clause that you drafted or that you kind of advised on, of like, oh yeah, you could do this escalation clause and maybe it'll get you in the right spot, but you didn't advise them to, you know, seek out an attorney. There was a form floating out there that didn't necessarily comply with what needs to be in there. Who was it prepared by? What's it for? The stated purpose, things like that. So I'm going to say all that. And I'm also going to say that I think it's a tough spot. I think you're likely asked a lot of questions. And this is just, I'm going to move a little bit away from escalation clauses specifically, because you can look at that article, you can look at the video. Like I said, I'm gonna have a little bit of follow-up to that, but it's probably a pretty fine line, I would think, because you are familiar with these contract forms and you're asked a lot of questions. And where is that line of, you know, am I engaged in the unauthorized practice of law right now, or am I just helping my client out and I know what that clause says? And it's always just going to be really fact specific. I think the last bullet I have on here is, does it feel legal-ish, right? There's a steady term for you that always has a clear definition. It doesn't. I think if you are advising and it has the potential to impact the legal rights of your client, if you're getting into, okay, if you fill this in here, it means that, you know, you're going to lose your right to terminate here and here, and I'm just sort of making that statement up. You're starting to get there, right? You're starting to get into the unauthorized practice of law, and I know you want to be helpful, but I think advising someone to consult with an attorney is really important. That's an important part of what you do, and I don't think you can say it enough. I don't think you can put it in writing enough. That's the lawyer in me, right? If you're advising them to consult with an attorney and you're documenting along the way what you're saying to them and really encouraging them to seek out private counsel, that's a good thing. That's, you know, that's helpful in the event a complaint is filed against you, showing what you've done. And I know that's hard, right? I bought my house. I mean, I am a lawyer, and they were like, well, she's a lawyer. You're a lawyer, so if you want to get an attorney, you can get an attorney. I had no idea what I was doing. I didn't know what any of those terms meant. Did I rely really heavily on my agent for that? I did. I probably shouldn't have in hindsight. I should not have. Fortunately, those contract forms are super helpful, and they cover a lot. And they make the process easier for your clients. But I just think when things start to get complicated, if they're asking you, hey, can you put this escalation clause in there? Hey, what does this mean? I have 20 different natural resource leases on this property, and I get money from here, and like my Aunt Elda is listed on here, but technically I get the money because I'm on the project. That's when we're in, you're going to need to contact an attorney. This is a big deal. For a lot of people, this is the biggest financial transaction of their lives. And it's a big deal. And so if the more you can stay in the safe zone and not speak to, what the potential consequences are legally, what this could mean, I think that's for the best. I also recognize there's a real world component, and you're asked questions and they're paying you, and there's a reliance on you. You have fiduciary duty. So I just think, you can cite statute, you can cite rule, and you can say, hey, I'm not allowed to do this. I have to do that a lot. I know it's hard. If somebody were to ask me a copyright law question, I would always say, oh, I think you need to see a copyright attorney for that. But then if they're like, yeah, but what about, kind of generally speaking, and then I can speak generally to it, but I can't really answer the question of, if you do this, then what happens? If I distribute it this way, what happens? I don't know. And it's okay to say I don't know and refer them to that private attorney. Okay. And document. I'll just always say that. Document all of those conversations, put things in writing, and it's very helpful at the end of the day. Should you need any of that documentation. Okay, and I was told that you all had some sort of general questions about the appraisal waiver. So the appraisal waiver form, I'm just going to say it, I think it's hard. Every time I read it, I have to do an example in my head for each one. I'm like, no, this is the one that means this. This is the one that means this. Okay, if I do this, I actually recommend, that's probably the best thing to do every time you look at it, is to remind yourself, okay, this box means this box means this. And I know it's really popular right now. We're getting a lot of questions, and broker lawyer, actually, they met on Friday and a little bit of a marathon of a meeting. Their meetings are always a marathon of a meeting, but super interesting. there's a lot of questions as it pertains to FHA and VA loans, right? Because you can't use that form with those loans because there's required language for those types of loans that exist in the third-party financing addendum. But we're, the market right now, can you even get a house with an FHA VA? Because if you're not turning in that appraisal waiver, is anyone even going to consider you? Is that market driven at the moment? Yes. What does that mean overall for folks with these types of loans? I don't know. Broker lawyers looking at it. They're looking at, what are those options under the third party financing? How does it relate to if your client, has more money they can put on top of that? And that's just really a process, a walkthrough. But it's something that this form and the third-party financing addendum, both of those are being considered as it pertains to FHA and VA. And also, this will come up in a second, also as it pertains to hard money loans and what that means, and is there room in the third-party financing addendum to contemplate some of these cash deals? So what I would say with the appraisal waiver form is know it, love it, or hate it. Either way, you have to know it. It's complicated. That's another one where, maybe an attorney, advising someone to consult with an attorney on that one, I think is a good idea. I think it's also helpful to just have I have my examples for each box that I keep for myself. Like I said, every time I look at it, I have to be like, okay, this one corresponds. Okay, if I put in this number and it comes under this, I just think that's really helpful. And then finally, I'll just say, this isn't in my slides. The broker lawyer committee met. So broker lawyer committee, I've mentioned them 1,000 times and then not really said who they are. And I'm not sure how well known they are. But they are the folks, it's a group of brokers and a group of lawyers. So broker lawyer committee. Although you don't technically have to be a broker. They are the ones who draft the contract changes. They are the ones who own the forms. When they present changes, they go to TREC, and TREC can either vote them yes or no. There's not really an in-between on there. But they meet pretty much quarterly. They get a ton of comments. So if you ever submit comments related to the contract forms, they're going to go to broker lawyer committee. In fact, we had somebody from MetroTex submit one on the appraisal waivers. I noticed that on Friday. I was like, oh, here we go. So they look at the kind of they did all the paragraph 5, the paragraph 4, that kind of stuff. And I'll give you a little bit of a preview of what they're looking at and taking into consideration. It's a pretty long list and they're getting started with it. The HOA form, as you may recall, there was language added, deposits and reserves, and there's some math in there. There's some numbers you put in there. What does that mean? HOAs have different names for things. Is that a deposit? Is that a reserve? Is it prepaid? Like what's happening here? And I think I see a lot of questions on the HOA form. They're looking at that. If you have questions, if you're struggling with that, I would encourage you to submit a comment to the broker lawyer committee, and you can see it. It's general. You send them to us, so it's general.counsel@trec.texas.gov, and we put them in a book for them. If you ever have comments on the new forms that are been ruled, that's a different process. We have an online comment tool. So you're going to see that. You're going to see they're talking about that appraisal waiver, the FHA VA loan. That's going to be the discussion at the next one. I think that one should be interesting. Oral leases, maybe they're playing with the idea of some disclosure on that. It exists in the farm and ranch. Does it need to exist elsewhere? And disclosure of MUDs. So similarly, there's new PID disclosure requirements. That's why there's been another change to the contract forms. So there's a new PID addendum form when you have to disclose. There's now there's statutory required language as it relates to disclosure of PID. So that language used to exist in the actual contract itself. Now it's its whole other form. Soon the PIDs will have their own forms. I highly encourage you to take a look at that form. I showed you earlier in the presentation where you can get the red lines. That red line version of the new 1 to 4 includes that language. And it references you to the whole new PID disclosure form. So I would just take a look at that, take a look at what that means, get with your broker, and see how you guys are addressing that. I know it's not everywhere, everyone, but I think it's an important one. And that, I think, is everything that I have for today. I'm gonna let Chelsea have her computer back unless anyone needs something from me right now. Just click to the next one. Oh, I'm sorry, I lied. I'm gonna turn it back to Mike, but Chelsea's gonna still drive the slideshow because I will fail at that. Thank you, everybody.
Hey, Mike, you're up.
Okay. Good morning, everyone. First, I'm going to preface it basically for our enforcement division. We rely on complaints, so we're complaint driven. So meaning rely on consumers to file complaints or license holders if they see something that they feel is a violation out there. A lot of times I explain to people, we'll get emails and say, is this a violation? Sometimes we can't tell one way or another. The most important thing is if you file it, we'll make that determination. And if it's not a jurisdictional complaint, the person that, that gets the complaint filed against them, they won't ever know that's filed. The only people that notify is if the complaint does meet our jurisdictional limits, then all parties are notified that we are opening the complaint for investigation. Chelsea talked about this earlier about economic growth and consumer protection. It's obviously a difficult balance, but we don't want rules and statutes out there that are going to impede the ability of economic growth. But we also need to be, the gatekeepers, so to speak, to protect the consumers in these transactions. I like to do what would be a progressive type of disciplinary situation. So basically, it progresses the more complaints someone gets filed or the more serious the violation is. So what laws do we enforce? We enforce obviously the License Act and the Commission's rules. We also regulate inspectors and timeshares as well. We used to regulate home warranty companies that actually transferred to the Texas Department of Licensing and Regulation starting in September 1st. So if you have a client that has a complaint against a home warranty company, that will be the place for your client to file a complaint with at TDLR. So I put this slide in here basically to walk through what brokerage activity is. I mean, a lot of people have, obvious ideas of what it is. The classic example is listing a house for a person for the expectation of compensation. So the key there is you're doing it for another person for the compensation. If you're doing some of these activities just for the benefit of your heart, it doesn't really fall into brokerage activity. But we also have a lot of non-brokerage activity items or exemptions. Be classic examples, principal, a buyer and seller. We also get a lot of questions from attorneys. Attorneys are actually exempt under the License Act, but they're not entitled to receive a commission. So they have to get any fee that they, as a legal fee from their actual client. They can't receive a commission from a broker like, a sales agent or another broker on the other side of the transaction would receive their portion of the commission for representing their clients. We get a decent amount of complaints in regards to people like, license holders that may have unprofessional or distasteful type of, behavior. If it doesn't really relate to a real estate transaction, then it's typically something we don't have jurisdiction over. Just like Chelsea explained earlier, we have had an increase of license holders, and it's actually translated in complaints opened. A good chunk of the things that we do in the enforcement division is also background history checks. So this rise has, this is not all consumer related complaints. It's also cases that we open for people's backgrounds. This is not an exhaustive list, but I mean, these are some of our common violations. We have questions about unlicensed business entities that are receiving a commission. If you're setting up an LLC, you need to have that business entity broker license in order to receive that commission directly. And I mentioned just a bit ago, we open quite a bit of criminal history and background history. A good majority of our people that are first applicants. So we also, if you commit a felony while you are licensed, then we will open a complaint and investigate that matter. They'll take up about 50%, a little more of our case openings per year. We also run into rebate questions. Of course, posting stuff for IABS and consumer protection notice and advertising. Those two last items kind of go hand in hand. And I'm going to talk about advertising actually in a minute or right now. So in general, what is an advertisement? I mean, I can say our enforcement division, we have an enforcement inbox, and there's an attorney that handles those on a day-to-day basis, Monday through Friday. And we regularly get questions about people's advertisings. While we don't actually technically approve an advertisement, we will answer questions about the advertising rules. Or I also always encourage, if you're a sales agent, go talk to your broker. Your broker should know these rules, possibly better than you. So they should be also a resource in regards to how to set up your advertising correctly. So in general, advertisement is basically anything that you're using to attract real estate business. So that could be even a personal Facebook page or other types of things. But I mean, obviously the traditional advertising methods are always hit there. So what do you need for your advertisement? You need your name or the team placing, because team and groups are really popular these days, and the broker's name needs to be at least half the size of the largest contact information. And so for a sales agent, that would be the sales agent's name, or associated broker, that would be associated broker name, or the team name. But those always have to be together. We don't require, we get questions about, do I need to have my license number on there? No, that's not, these are the basic items that need to be on any advertisement that you're trying to solicit brokerage business. We get questions about, is the broker's name the same as the team name? The answer is no. Basically, the broker's name is what's shown on their license, or could be a alternate name or assumed business name, or what a lot of people would know as a DBA. Those need to be registered with the commission, but they're significantly different in the team name because they're the ones that broker name needs to be on all the advertisements, half the size, like I explained earlier. An alternate name would be, something that's totally different than what's on your license. Like, for example, here, if you're using a middle name, or for instance, my name's Mike, and I want to, I just go by Jimmy for some reason or whatever, that needs to be registered with us, especially if you're either a broker or a sales agent, you need to register those alternate names with the commission. So we can go to the next slide. We get a lot of questions about social media. The easiest thing in these is the one-click rule. So you need to have your information with your broker's information, either with a direct link or on the user account profile. Now, I get a lot of questions about, well, especially if you don't have a business, let's just use Facebook, for example. You use, your Facebook page for, personal reasons and, for possibly, business reasons. If you're posting occasionally, like your listings, or you're trying to solicit, business using your personal Facebook page, it's going to fall in that category that's going to need this information that's required, because then it falls into the business website, business, social media category. So take that into consideration, even if it's on occasional use. Then, make sure you get your user profile on Facebook or any other social media compliant with the rules. This question came up as part of the questions that you solicited us originally. There was someone that asked about what kind of jurisdiction does the commission have in regards to agent conduct during like a showing. Been several examples that we've had over the years, and this would be someone setting up like a showing, going in and looking through drawers they're not supposed to be going through, or possibly doing other inappropriate behavior in houses. We had an example, I guess, a few months ago where someone scheduled an open house, I believe, remember the facts correctly, and they left the open house and allowed the person to stay there. They did some sort of YouTube video because the house was really pretty, so they wanted a backdrop for that. The rules that fall into here are basically if someone's acting negligent in what they're doing, or in some other more serious functions, they're misrepresenting their intentions in going into the property. That's why I say, breaching their fiduciary responsibilities or, bad faith, But there's a companion rule that goes a little further than that, and it's basically our misrepresentation, bad faith. That's where we've couched a lot of these types of complaints. But we look at it really on a case-by-case basis and what their intentions are. If, this is an agent just physically using their super key to break into a home, but that's a criminal act. So that would be like criminal trespass, or if they actually did they take something from the property, then that could be possibly burglary of a habitation. So that's when the police also get involved. We will in some cases allow the criminal system to process that case. Then if it's a felony, then we can take appropriate discipline. Doesn't mean that we can't take discipline independently. We just need to look at it from a case-by-case basis and see what their intentions are, especially if they're scheduling this as a showing and then they're going to do this. That's definitely allows us to assert our jurisdiction much better than in other situations. That wraps up everything we had. I think there's some questions that we're all going to field together.
Stop sharing our screen so that you can see us all. Vanessa and I are going to share one camera. So we are happy to answer any questions you have. I know there were several questions that we already know you have. I'm happy to go through those, or just pass it back to you, Sherry.
Okay, well, let's go ahead and take some of those. I think you guys were doing a pretty good job as they were coming in. Let me go ahead and people, you do have the opportunity here to go ahead and put your questions in the chat. We were able to get some from professional development, some questions from committee members. I'd like to go ahead and let's start with those as people are thinking about putting their questions in the chat here. One of the questions we had was TREC has a minimum standards of practice that's in place for the inspectors. Is there any possibility or any thought process of putting in the future kind of that SOP, the operating procedures, standard operating practice for realtors, something that the consumer could at least have a baseline of what to expect?
I'm going to let Mike start that one, and then I have a few things to say about it. But Mike, do you want to take it? Yeah.
So when you look at inspectors versus sales agents and brokers, I mean, their activities are, I would say, starkly different. When you do an inspection, It's usually, it's the SOPs are written for residential inspections. They're usually code based. So there's some sort of root of that type of standards. And there's not many ways you can vary off doing a home inspection. You may find a lot of different things wrong, but if you look at brokerage activity, you can go from property management to, buyer representation to listing houses. There's just a very myriad. I mean, the definition of brokerage activity, is very long. There's several things that fall in there. The definition of a real estate inspector is literally like 2 lines long, in the statute. So I haven't, I think in some means there'd be some guidance in that, but we really could look at it, at least in the enforcement side, they have a lot of, institutional knowledge. So we know what, proper common practices are for realtors. And, when we have to prove up violations, you can show that, they're taught this way. If you go through their classes and those types of standards, I just think there's just way too many variables to do something like that.
It's not a bad idea for specific brokerages to have standards of practice, kind of an elevated standard beyond what the TREC's rules and law requires. I basically think because the work that sales agents and brokers do is so much broader than the work of an inspector, that a standard of practice document coming out of TREC would be so long that it wouldn't be particularly helpful.
That makes sense. Let's jump over to the chat quickly for this one, because I think it kind of ties in a little bit. Is an agent that misrepresents their performance history in advertising a TREC violation?
So if it could be considered a misleading advertisement, that would be something that would fall into it. I guess for performance, like their sales rates or something like that, or
I'm going to assume, because we have had this question over the years, when an agent sends out, and Todd, please jump in. Also, if an agent uses a piece of advertising to show their sales in a certain marketplace when they are really piggybacking off of other agents' sales, and using it as, instead of just sales that have occurred in this neighborhood, it appears in the advertising that they possibly are responsible for those sales.
Yeah, that's what we look at for misleading advertisement, those types of things.
So
we
we'll
obviously
put in
go
a
for on a
plug.
case-by-case basis. It depends on the context. We just have to look at the full picture and what the actual wording is and stuff, but yeah.
The hard part is that we don't take it anonymous complaints. So we rely on other people identifying a violation and submitting it. And then we do the investigation from there. So that would be a perfect example of something to submit.
Okay. Let's jump to expectations. We've talked about the standard operating procedure, and that makes perfect sense. It's just a little too broad on our side of the industry. But regarding those expectations, one of our members wrote in the hang your license or broker for hire concept often omits the onboarding, training, potential supervision of agents. Could we expect any changes to those requirements for the brokerages and the minimum expectations?
I can start with this one. I should preface, I can't speak for the commissioners themselves. So, I know a lot of them have concerns about broker supervision in general. And, it's important for, for the commission as well, that, that's why we have that broker supervision rule. Yeah, there aren't any set standards in regards to how you onboard a sales agent. And there's no proximity requirements in regards to, a broker being, within the same county as the sales agent that live in there. That's just, one of the things where the statute set out. But, we have high expectations that the brokers, knowing what their sales agent's doing, if they're not, and complaints get filed against them, we're going to look at that because, we open complaints against all the parties. So if someone files a complaint against a sales agent, their broker gets added every single time in every complaint. And we're asking what they were doing and getting a response from that broker about what they did, in this transaction and what their involvement was. It shows very minimal involvement and it's serious and they should have known what was going on, then, they get a chance to get disciplined. So, but I'm not sure I turned around that question, but some of the better brokers they have good training programs and they have a set out policies and procedures out there that kind of gives that sales agent some guidance of what they expect from their sponsors, and it also limits maybe their type of practice to a certain level until they become more experienced as well. So
here's an interesting, just inquiring minds want to know, who is TREC to the licensee other than issuing the license?
I'll take this one. I'm thinking this is one of the reasons that we want to do a better job at outreach, because just by I filed it away, I see it as instructive that question is even needing to be asked, right? But essentially we are a licensing and an enforcement agency. That's the reason we exist in state government. So we issue and we renew licenses. We write curriculum for mandatory education. We approve all other courses. We've opened more than 7,500 enforcement cases in the last year. We evaluate backgrounds. We provide answers to questions about your license, both through the enforcement division. They take thousands of calls a year. And then also our customer relations division last year fielded 230,000 phone calls and answered more than 57,000 emails. So we have about 20 to 23 people on the phones on any given day, just answering your questions. Now, I'll tell you that one of the first things we say to sales agents who call with specific questions relating to their practice is, have you talked to your broker? Which that goes to the last question you ask, right? But we very much want to equip our license holders and to be a resource for our license holders. We also speak to people like you. You'll notice that there's not a single person from TREC on this call that is part of our licensing department. I oversee that department as executive director, but today we've got enforcement and our general counsel with us. So clearly we are more than a licensing agency. We're never going to fulfill everyone's wildest dreams, but we want to fulfill our role well, and that is to support your work and to protect the consumer. But it's important to me that all of you know what we do and how we can help. I think, I am a lawyer by trade, and so I am regulated by the state bar. I don't know who runs the state bar. I don't want to participate in all of the inner workings of the state bar. I just want to make sure that I'm following their rules so that I don't get in trouble, and I want them to keep my license. And so I know that there are a majority of people out there who are like me in that regard, and that's fine as long as we can fulfill their needs as they arise. But for those who want to be more involved with TREC and to know the inner workings, I want to fulfill that role as well.
Right. One of the questions, as you can see, we had a great meeting last week before our actual meeting on our run through. And one of the questions that kept coming up, is there a discussion on limiting the number of agents any one single broker can sponsor?
There's definitely discussion about that within the field among you, and the question often comes to us. There's nothing on the table at the commission level to limit that. And one question that I often ask brokers of both small and large brokerages is, how do you supervise well? What do you do? And to be frank, I've seen some large brokerages do very well. I've seen some large brokerages that don't do so well. And I've seen some small brokerages who do very well and some small brokerages who don't. I think sometimes it doesn't depend so much on the number as much as how. And the how is very important. And the challenge is that so much of the how is specific to your business structure, which is a decision for every brokerage.
Absolutely. We've got Todd back on. Thank you, Todd, again for another great question. Has TREC studied the impact, if any, of the appraisal waiver on market price escalation?
So I can speak to that a little bit and say, no. No, they haven't, but I was trying to mention this earlier. I think there is a lot of room for discussion on that appraisal waiver form, especially as it relates to the current market. I think that group does not want to make changes or draw conclusions from what you're seeing right now, because it's a little bit wild right now. And they look more to sort of the steady, what is it normally like? But I think that's a really great question. That's one that you could send into that general counsel. It's just general.counsel inbox, and it's in the slideshow, because I think that's a great point. And what does that mean now is, what can broker lawyer, the commission do with it necessarily? I don't know, but I think raising the relevant real world issues that you all see that we don't is really helpful. And I always know that when I speak, even just now, I am speaking to an industry that I am not a part of, which is a good thing. But also I want to know what's really out there. Do you think that's happening, Todd? And if so, what do you think the implications are of that? And getting us that information, that public comment, and what you're really seeing can help inform the way in which we move on some things. I don't know that we move on that. I don't know if that's right now, is it forever, but is it something that you can bring to our attention and that we'll take a look at and monitor? Yeah, I think absolutely. I want to know what's really happening, so that I'm not just speaking to sort of well, this is what the law says and this is what you should do. And then, I mean, how helpful is that when you're like, yeah, but all these crazy things are happening and you have no idea what it's like out there, right?
The broker lawyer committee did discuss this a little bit at their meeting on Friday, so you can always go back and look at just the beginning of that discussion. I think it's something that will continue to be talked about significantly. We in state government tend to operate like a locomotive. It takes a little while to get us going, and it'll take a long time for something like this to be fully developed. Our market might be totally different then, but it's a very important conversation to be having. I wish we could give you more, Todd.
Yeah, and I'll plug the broker lawyer committee one last time. And I don't think the recording is out yet. I think Amber's actually working on it right now, because it was truly just this last Friday. They are long, but listen, if you retain 20% of what even just the chair says, was amazing, you will walk out of there so much smarter than you were. It's really incredible. And the ways in which they discuss how these clauses interact and what this means. And also, well, historically, we haven't made that change to the waiver because of X, Y, and Z. And you're like, oh, I had no idea. That answers my question. I think they are so informative. They are really long, but they are so informative. So I really encourage, if you go up to our meetings and minutes pages, we have recordings of all of our committee meetings, the commission meetings. Most of them are done in such a way that they're
clickable.
And the minutes. So like, if you really are just, and I can't make this promise for broker lawyer, because broker lawyer just covers so many comments. It's incredible, but you can click on the actual item. So agenda item 13 relates to appraisal waivers, and then you just push the button and that part of the discussion on the video pops up. And that's really helpful. I can't promise that for broker lawyer, but it's a really good resource. And also, I'll just say it again, you all are our best resource for what's actually happening. So I always encourage, I may annoy you and say I can't answer your question because I can't give you legal advice, and it's not because I don't want to answer your question. But I'm in a little bit of a different role, but throw those questions and those comments to us so I can filter them when I can, like spread them out when I can. And if I can't answer it, or if I can kind of cue you in a certain direction, I will, or I'll send it to Mike. He loves that.
Well, I can tell you, if it's not, if you're not sure what our involvement can do, we've seen trends and the cause and effect of that over the years. After the last 2 decades, we often talk, whether it's Forms and Contracts Committee, professional development, in our own brokerages. The special provisions paragraph used to be this long, and it used to be all blank space. And what is blank space for? It's for us to write stuff in. Now it's about, like you were doing, Chelsea, it's about like that. So we've adapted the contracts, we've added addenda, we've done things that have been trend related, even just changing some of the language within an existing paragraph to meet up with current trends. And so it is so important to have that involvement. We never want our agents to feel that their voices don't have a play, because that is where that information is coming from, the ones that are on the ground. So we appreciate that. What are some hot, oh, here's a good one. You all three are going to love this one. What are some hot issues now that you guys can give us the super secret word on the street? What's going on now that TREC is working on behind the scenes?
Well, we have no secrets. I'll start there. We'll tell you everything you want to know. And I mentioned a few of these in terms of some of the initiatives that the commission is considering for 2022, but there is a lot of conversation around wholesaling. Wholesaling is the concept of putting an offer on a property with no intention to close on that property, basically selling your interest in the property before closing. And so the commission will look into that. We're talking about license portability. The governor directed all licensing agencies a few years ago to decrease barriers to entry in all licensing fields. And we have examined that some, knowing that Texas has some of the highest requirements for license to receive a real estate license. I think there's some examination, though there's great tension around that. As soon as you say, what if we lower our requirements, you have a huge collection of people saying, we need to up the standards for our license holders. There are so many in the field who are just not doing a good job. We need more education. We need higher standards. We need, that sort of thing. So I don't expect for requirements to be reduced, but they might be toggled. Substitute experience for education, something like that. The Broker Responsibility Working Group has submitted some of those recommendations for a couple of years now to the commission to seek some of those changes at the legislative level. And it just hasn't been the time for the last couple of sessions. 2 sessions ago, the agency was going through a fairly tenuous sunset review process. Last session was just a very different session with COVID in the picture. That fewer bills were filed, less was passed. There just wasn't much of an opportunity, but I think the commission will move towards lowering the broker education requirements, but then increasing the experience requirements and doing a toggle there. And then I think there's just going to continue to be a lot of conversation around how best to educate and equip our license holders given our current market. This is a wild world we're in. And that will include, Todd, your question on the appraisal waiver. That there's a lot of facets to that, but just how best to equip folks given where we're at today. So none of that super secret, but I see those as the hot issues moving forward.
Okay. Well, we're going to throw one more out there from Jared, talking about what changes and what things are happening in the marketplace. Is there a plan to start enforcing rules regarding vendors who have become brokerages? If they want to break the rules, they hide behind one status versus the other. And of course, Jared is putting himself out there saying he has specifics that he can certainly cite if need be. But there is a lot of, there are a lot of words for it out there, but the word we hear often is disruptors in the marketplace.
Sure.
That's the word we hear.
Yes. So, we do not regulate a business structure, business model. And I know Texas Realtors also says they don't really comment on business structure and how an entity decides to run. There are certainly disruptors out there. They're all required to follow the same rules and law that all others are. But as you have those disruptors, it's kind of, is it square peg round hole? It's a different kind of examination. I recently had the question of, a newish platform out there that does advertising for other brokerages, but they're also a brokerage. So what hat are they wearing? And the rules that we require of them depends on what hat they're wearing. That came to me as kind of a hypothetical. So it's really hard to dig into the details of that in the hypothetical. But so within the hypothetical, all I can really say is we require the same regulatory requirements as any other. But it's very fact specific. So in order for us to wade into those waters, we need to have an actual complaint, to do an actual investigation, to basically test it through real world experience. How's that for not very helpful?
Well, okay, so let me ask you this. This goes to another member's question. How would, because not everyone knows, how would an agent best get that question to you, that tip to you, that concern to you? Michael, is that you? How does that process look? The literal process of, we see what we think is an infraction, a problem, to report. Easy. What do we do?
You go to our website, trec.texas.gov. And if you can either do in the search, there's a few ways to get to a page we have that is how to file a complaint. So you would submit a complaint with those facts included.
Easy enough.
If we also have an email address for questions. The hypothetical is not a great one to do there, but if you have a question as to how to comply, enforcement@trec.texas.gov is an email address that gets you to an attorney on the enforcement division. So it's enforcement@trec.texas.gov. It's very similar to the general counsel inbox, which is general.counsel@trec.texas.gov.
Do we have any other? We had Jared and Todd. I want to make sure that we didn't miss any in the chat here. Just looking to make sure that we had gathered them all. There is one here on the list that what prompted the change in the, and this was a new one, what prompted the change in pre-licensing, whether for realtor or broker license, to require proctoring of course exams, not final, but course exams? And I know that was instituted before you guys were on board, but do you know any of that?
If I am remembering that right, I think I was here for that. we changed what was required for the exams. And that came through ESAC. That was a recommendation out of our ESAC group, which is the Education Standards Advisory Committee. They reviewed several pieces of our testing requirements, our proctoring and testing requirements, both for pre-license and CE, and kind of submitted that as a package deal, if I remember that right. But all of our education changes go through that ESAC group. And I think we received another question of, how do we submit comments or questions on forms, or how do we bring concerns to TREC? And the answer is always to get involved in the committee process. ESAC for education, broker lawyer for forms. We have broker responsibility, which is more of a working group, similar to the other two. It's just not set in statute and rule. So that committee process is where the rolling of sleeve type work comes into play. And they welcome comments by visitors who just participate in that process.
Okay. Well, I am not seeing anything else come in at this time. So unless you guys have some closing comments you would like to make, we're open for that.
Well, I will just say thank you for participating in this. It's very meaningful to us to just have time with you. With there being 218,000 license holders, putting faces to the licenses it's very helpful. And I also want you to feel like we are accessible. I've given you a few email addresses. You know our names probably from an email or from our introductions, but also an email sent to you that got you to this Zoom meeting. Our email addresses, mine is chelsea.buchholtz@trec.texas.gov. Mike's is michael.molloy at the same. Vanessa is vanessa.burgess. Feel free to be in touch with us. Our virtual doors are open, and we're delighted that you would spend some time with us this morning.
Well, thank you all very much. It was very informative, and we appreciate, as always, you guys taking the time for us. So without further ado, Chelsea, Vanessa, Michael, have a wonderful rest of your day, and thank you for joining us.